This morning I published an article in Ammoland, and I'm proud to have done so. It's an article whose idea I floated at the Gun Rights Policy Conference sponsored by the Second Amendment Foundation a couple weeks ago. It's an idea about how we get around this sort of odious case involving Zackey Rahimi. It's very creative, historical precedent exists for it, and you will only hear it here at the Four Boxes Diner. Stay tuned. You're not going to want to miss this. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of First They Came for the Gunners, the A to Z guide of how the anti-gunners intend to take away our rights. Don't miss out on getting a copy today. All right, folks. So I published a great article, and I think it's a great article, an important article actually, in Ammoland this morning. It was an idea I floated at the Gun Rights Policy Conference, sponsored by the Second Amendment Foundation a few weeks ago in Phoenix. It was a great time. Enjoyed myself, enjoyed talking to a lot of people in the Second Amendment community. But let me tell you what this idea was. The idea is, how do we deal with the situation of Zackey Rahimi, who, based on the court record, appears to have be an odious person, or certainly have done some bad things, which landed him in federal prison for violating 18 U.S.C. 922 G8, which, as you know, is the law in front of the Supreme Court in the Rahimi case as to whether or not a person who is subject to a quote-unquote domestic violence restraining order cannot possess a gun during the time of that restraining order is in effect, and whether or not that's constitutional under the Second Amendment and the Commerce Clause and some other arguments that we'll get to in other videos. But one idea I had, and this is one of the benefits of being a constitutional scholar and a student of American legal history, is I know how the left acts. In fact, several years ago, I wrote a book called Disrobed that talks about how conservatives can use the tactics and strategies of the left to advance our agenda in various ways, including with respect to the right to keep and bear arms. But we don't need to get into that book here. The point is that I am a student of what the left has done and how we can benefit from it. How to hoist them on their own petard is kind of the question. And there's something out there that we can use, in my view, to get rid of the Rahimi case without risking damage to our right to keep and bear arms and to the very successful and helpful Bruen-Heller interpretive methodology of Second Amendment cases. This notion is called strategic mootness, or mootness. Now, as you know, under Article 3 of the United States Constitution, Article 3 creates the federal court system and the jurisdiction. In that, it talks about something that says that in order for a federal court, including the Supreme Court, to have jurisdiction over a case, it has to be dealing with what's known as a case or controversy. Now, that case or controversy is an active, live fight dispute between multiple parties, between two parties at least. The reason why I bring this up is if a case is mooted, meaning there was a dispute between the parties, and then after the filing of the lawsuit, that dispute goes away and is no longer an active dispute, that case has become what is known as moot. Moot. So let's say you and I get into a fight about a contract, or we get into some sort of fight, we go to court, we sue each other, and we sue each other all the way up to the United States Supreme Court, and in the middle of our case before the U.S. Supreme Court, we settle the case, or something happens that makes the case go away. The Supreme Court will almost always dismiss that case as moot, and we have to dismiss it as moot because under Article 3, we are only allowed to hear cases and controversies, meaning actual live cases and controversies. Those cases that are moot have to be dismissed. We lack jurisdiction. So what this means in the context of Mr. Rahimi is this. So my idea that I floated at the Gun Rights Policy Conference was that the district attorney, the criminal district attorney in Tarrant County, Phil Sorrells, who has run as a conservative and appears to be, for all intents and purposes, a strong conservative lawyer and politician and district attorney. Looks pretty good to me. Seems like the kind of guy I would probably want to be my district attorney if I lived in Texas. The point is that I explain how he actually is the critical person who has the ability to be a superhero. Specifically, that District Attorney Sorrells has the opportunity to essentially make sure that Mr. Rahimi serves a substantial prison sentence while simultaneously saving the Second Amendment. And how would this work? Well, the way I see it working would be that the district attorney could speak to the attorneys for Mr. Rahimi and basically propose something along the lines. Now, again, the specifics would have to be worked out, consistent with, court practice and all that. I'm not going to get into the specifics there. It's really just floating the idea for people to consider. And the way I would do it would be something like this. I'd reach out to Mr. Rahimi's attorneys and say, why don't we talk? And then I would say, I got a deal for you. It looks to me that there's a very high likelihood that the U.S. Supreme Court is going to reverse your client's victory in the Fifth Circuit Court of Appeals. So why don't we reach a plea agreement? It goes along the line as follows. Your client, Mr. Rahimi, will waive all of his defenses to his criminal conviction in federal court, including any and all defenses to his conviction under 18 U.S.C. 922 G8, which is what we're fighting about in the Supreme Court. In particular, Mr. Rahimi will waive his defense that the statute is unconstitutional under the Second Amendment. In exchange for agreeing to serve his full federal sentence and to remain in prison and to be convicted under federal law, in exchange for that, the District Attorney Phil Soros, as I see it, would essentially say, in exchange for that, I will cut you a deal of some sort dealing with the multiple pending state court charges for the various shootings that have occurred in Texas, in my county, which I believe are pending right now. Now, we're not going to give you no penalty or no punishment. We're going to have you plead guilty to some of the state court charges, but I will find a way to cut back on the scope of the sentencing that is possible, because as I understand it, based on the record that I've been able to read, no one was actually shot by Mr. Rahimi. He shot at people, but he didn't actually hit anybody, which is a good thing all the way around. And as a consequence, I think that the deal could be cut that says, look, you're going to plead guilty to these state court charges, but we will cut back on the amount of the sentence. Either we will allow your sentence to run, let's say, concurrently with the 6 or 7 year sentence. That is the case right now. You have to serve in federal court right now, or we will just extend that sentence out a few additional years where once you leave the federal system, federal prison, you will come over to Texas State and you will serve in a few additional years in the Texas State prison system, and we will call it square. So from Phil Soros' point of view, as I see it, it's a win-win, because he is going to be able to show that he really did hold Mr. Rahimi's feet to the fire by making him give up his federal defenses and forcing him to serve whatever it is, the 6 or 7 years he's been sentenced to in the federal system, and of course some additional penalties associated with the state thing. But at the same time, he will prevent a situation where the U.S. Supreme Court, messes up by virtue of allowing the old cliche of bad facts make bad law to take advantage. Now, keep in mind that he's an elected official down there in Texas, and I'm guessing that, if he is blamed for screwing up the Second Amendment in some way, that may not be a big winning argument down there in the state of Texas if you're an elected official. So to me, it's a way for him to have his cake and eat it too, and really be a Second Amendment superhero. So he really would serve as an exemplar of the best and finest of district attorneys in the country, at least in red state jurisdictions, if you will, where he's respecting the rule of law. He's respecting, ordered liberty and law and order, which is very important because law-abiding gun owners do want violent felons to go to prison for a whole host of reasons. But at the same time, respecting the right to keep and bear arms is found in our Second Amendment, in our Constitution, in our Bill of Rights. So I think this sort of balancing of interest is the sort of thing that the district attorney down there in Tarrant County could really serve as a great example and could solve a lot of problems. And by virtue of Mr. Rahimi cutting this deal, it's quite possible that he would be able to then file a motion to dismiss, saying that he wants this case removed and dismissed because it's now moot, because he's no longer challenging his federal conviction. Now, you may say to me, Mark, is this idea that you have insane? Is this just another one of your, great, crazy ideas that you come up with that no one else has thought of? Well, I guess here's the thing. I have a lot of ideas. I have a lot of ideas that I think of that nobody else thinks of. But here's the interesting thing. This idea of strategic mootness, meaning a case that's a live controversy gets mooted during the pendency of the case for strategic reasons, is not unusual. It does occur. Usually, however, it's done by, you got it, the left in America. So I gave two examples in my Ammoland article. I'll put a link to it down below. One is a case in 1997, a very famous affirmative action case, or a reverse discrimination case that arose out of Piscataway, New Jersey. The name of the case was Piscataway versus Taxman. In that situation, there were the facts were there was a black woman, an African-American woman who was teaching in school, and a white woman that was teaching in school. And basically what was alleged was that the school decided to cut the white woman and fire the white woman to make sure that the black woman, African-American woman, kept her job. And this was an example of race discrimination where they discriminated against a white woman to benefit an African-American woman. Now, that was the allegation, that was the record, and it went all the way up to the U.S. Supreme Court, and the Supreme Court granted cert. They were going to hear the case. And what happened there is that civil rights groups got together, pulled some money together, and they paid off the white woman, who was the plaintiff in the case, a considerable amount of money to settle the case while it was pending before the Supreme Court. When that occurred, after she got her money, she and her attorneys filed a motion to dismiss the case with the United States Supreme Court saying, hey, I've settled. I don't have an actual case or controversy anymore. It's now moot. And the Supreme Court granted that motion to dismiss, and the Piscataway versus Taxman case, which many conservatives and people that opposed race discrimination in all of its forms, even if it's in the name of racial quotas or whatnot, that opportunity to have the Supreme Court declare race discrimination illegal in all reforms, in all respects, was basically eliminated. The opportunity for that Supreme Court precedent disappeared because, again, the case was dismissed before the Supreme Court could actually issue a ruling. Now, this is not the only case. And for those of you geeks out there involving the Second Amendment, you know probably what I'm also about to say. You remember a few years ago, NYSRPA versus the City of New York. This was a case involving New York City's laws involving New York City permit holders who had home premise permits where they could have a gun in the home, but they could not carry it in public, and where they could bring their gun to target practice. And there were specific rules that allowed them to bring their gun in a locked container to certain places, gun ranges in New York City, but they weren't, as I recall, allowed to bring it to places like Long Island or to places like New Jersey, even if it was a locked box separate from a container, because it violated New York City regulations. And this went all the way up. And indeed, after the city won at every step of the food chain involving the federal courts, the Supreme Court granted cert right after Justice Brett Kavanaugh became Justice Brett Kavanaugh. And this looked to be another case where the Second Amendment was going to be embraced, affirmed, and expanded. And of course, that was of great concern to the anti-gunners, to New York City, and even to New York State. So what happened there was New York City, as soon as the Supreme Court took this case, they immediately amended their laws. New York State amended their laws. And basically, to make a long story short, the regulation and law that prevented carrying a gun in a locked box, concealed, blah, 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 to a gun range outside of New York City was amended to now allow a permit holder for a home premise permit to carry their gun in a lockbox separate from the ammo to gun ranges outside of the scope of New York City itself. And yes, indeed, this was after the Supreme Court granted cert, after the Supreme Court had filed papers. The Supreme Court even heard oral argument, and guess what the ruling was in NYSRPA versus City of New York? They issued a ruling that says, indeed, the case was now moot and had to be dismissed. So my suggestion that I lay out here as an idea is that Phil Sorrells, the attorney general, the district attorney in Tarrant County, Texas, could take a lesson here from Piscataway versus Taxman in 1997, and of course the Second Amendment case on NYSRPA versus the City of New York a couple years ago. Both examples of what I would consider to be strategic mootness or mootness of a pending case before the Supreme Court, and to do exactly this so that we don't see a situation where the terrible facts alleged in the Rahimi case distort Second Amendment jurisprudence for law-abiding gun owners across the country. All right, folks, hope you learned a little bit something here today at the Four Boxes Diner. Learned a little bit something about strategic mootness, how it might impact potentially the Rahimi case. And again, if you don't follow me on Twitter or X at Four Boxes Diner, make sure you do. And don't forget to follow us here at Four Boxes Diner. And again, we will see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.